Okay, everybody, we will get started here. Welcome to another Proline Academy session here, and thank you for joining us today. My name is Catherine Squires-Basson. I'm the Director of Culture and Community here at Proline. And today I'm joined by Christy Tamburi and Dario Anselmo, who will both be presenting today. I'll introduce them in a second. But first, I just wanted to give a little bit of background information before we start the session officially. So as you may know or may not know, we here at Proline, we offer a number of different opportunities for learning, both for our Strata Council members and for the residents and owners in our Strata communities, like today. These Academy sessions are presented by our own team members, and they dive deeper into specifics around how Strata corporations and communities function. They're also geared to councils and, like I said, sometimes also community members like the session today. So we have over 400 people registered for this session from all over the island and from a wide variety of strata corporations. So just as a note, because we have so many people joining, some of the very specific questions might not get answered if they are pertinent only to your particular strata. However, sometimes questions that sound very specific are actually really common. So we will be welcoming those questions later on in the session. In addition to sessions like this, we also offer lunch and learns, usually with council members. They're online as well, with a variety of experts like lawyers, plumbers, and insurance professionals. All of these sessions and today's session are being recorded, and then we will send out a link to everybody who's registered once the recording has been processed and posted to our YouTube channel. Our past recordings are also posted on our YouTube channel. So if you're interested in learning more, please check those videos out. As always, if you have any questions or suggestions regarding this or future sessions, feel free to reach out to me directly. There'll also be a quick survey, that's the word I'm looking for, survey at the end of the session. So if you do have feedback, it's always great to get that information there, and it helps us adjust for future sessions. There are a few housekeeping details for today's session. Everybody's videos and microphones are all off. This is a webinar, so we can't see or hear you. No one can see or hear you. If you do need to get in touch with me or you have any questions, you can use the chat function, and that will help. Questions about the format or if there's something that's not working for you. If you have a question about the content that you want the presenters to address at the end of the session, please use the Q&A function. You can put your questions in anonymously or with your name. Either one is fine. That means that everyone can see the question, and then it can be addressed at the end of the session. So we will have time at the end of the session for Christy and Dario to go through those questions. And I think that's all for me. Again, feel free to chat if I've missed something. I'm going to hand it over now to Christy. She's a Strata Property Manager and one of our managing brokers. Has been with Proline for over 10 years, and Dario, who's also a Strata Property Manager and one of our supervisors in our Strata department, and has been with Proline for over 5 years. So that's all from me, and I will be quiet now.
Thank you so much, Catherine, and welcome everybody. So before we jump right into bylaws and beyond, I just wanted to touch on Proline Management's purpose. Our purpose is helping people live and grow together, and we really do love working with clients that ultimately share this goal. There really is so much that we can accomplish together. Proline is locally owned, focuses on stewardship, building up our people internally, and then in turn our community. We are now managing over 14,000 units. And so we believe that we really truly have a unique opportunity to positively impact our communities. So as Catherine said, this is a part of our Proline Academy program. We provide learning opportunities for Strata Council members and community members, primarily virtually at this point, and we've been doing this consistently for the last 2.5 years, which is great. We have presented on a variety of topics, including nuts and bolts of strata corporations, bylaws, which we'll be expanding on a bit today, creating community, understanding strata financial reporting. And as Catherine mentioned, we've done a number of lunch and learns with expert guest presenters. Please do check out our newsletter for new offerings. And as Catherine said, we do send out email invitations to anyone signed up for the newsletters as well. If you receive an invitation, feel free to invite others. We want to get the information out there as widely as we can to help people understand the strata world. And again, as Catherine mentioned, the recordings are also available on the YouTube channel for review afterwards. So having said that and setting the stage, I'm going to pass it over to Dario, who's going to talk about why we're here and why we're bothering with this.
Great. Thanks so much, Christy. So why are we here today? Simple answer is that you live in a community and you live in close contact with others, and that can be really hard, especially when people are new to living close together. So communities often function most effectively when neighbors and everybody understands what's expected of them, what they can expect from each other, and how they can best act in consideration of each other. Good rules and bylaws can help set clear expectations and can reduce the conflict that comes from confusion. And there is a lot of confusion because stratas are complicated. We share information like this session in order to help you and your neighbors make better sense of how this is all supposed to work so that your communities can hopefully live a little bit closer together. And one particular aspect we want to focus on today is your bylaws and what is beyond them. So most of you probably know that your bylaws are limited by the Strata Property Act. You can't make a bylaw saying that Gladys is elected president for life of the Strata, no matter how much we all like her. But what else impacts your bylaws? What provincial laws impact your bylaws? What about federal laws and municipal laws or privacy legislation or human rights? Today we're going to get all into the basics, but we're also going to get into a bit of the rest of that stuff. And so if we go to the next slide, just a brief look at what we're covering today, all the myriad different considerations. Once again, first and perhaps most obviously, your strata's bylaws and rules. You have the Strata Property Act that is passed by the provincial government. And that's kind of where the buck stops. If the act says the strata must do something or can't do something, then that's how it is, regardless of what your bylaws say. Christy will be covering a little bit later what to do if your bylaws end up contradicting the act. But the short of it is that if your bylaw contradicts the act wins. You also have strata property regulations, which is like the act. It helps determine how the strata runs. The regulations are much easier for the province to change. So I like to think of it similarly to strata rules and bylaws. Bylaws you have to take to a general meeting of all owners to change. And just like the government has to take any changes to the Strata Property Act to the legislature to change. Meanwhile, your council can set rules just in a council meeting. And similarly, the government can change the regulations without a formal vote in the legislature. They can just announce a change into the regulations. And so the regulations are usually used to add some flexibility to the act. They usually just clarify or add specifics. If you read the Strata Property Act, you'll see a lot of things that say, for example, you need to get a new depreciation report once in a while and go to the regulations to see how often. And then it's the regulations that will say, used to say 3 years with some addendums. Now it says 5 years. So that's, how often you have to get a depreciation report is something that can be set in the regulations to allow the government to change it a little more flexibly. But then we go out a little bit from that and you have courts and tribunals, and this is where it can be a bit trickier. We have the Civil Resolution Tribunal, the Human Rights Tribunal, the BC Small Claims Court, all the way to the Supreme Court of BC, and these all have the ability to interpret the Strata Property Act and regulations. So the act says, for example, that you need approval of owners at a general meeting before significantly changing the common property. Now, what counts as significant? The act doesn't say, the regulations don't say. So the only way to really find out is to read court cases and find out what judges have been considered to be significant and not have been significant, and what cases have overturned other cases. And sometimes we can help you with that, but this is where we often need to rely on lawyers to sort through it all. And you can usually go and find these cases online by searching something like Strata CRT cases about security cameras. Sorry, then there's other legislation. This is a long slide. I apologize, Catherine. Your bylaws can't break the Strata Property Act, but can they break municipal bylaws, the Personal Information Protection Act or the Human Rights Code? How do you even know what all is out there that impacts your bylaws? Especially as volunteers, how do you make reasonable decisions about how Strata should operate? Again, sometimes reading a court case, we can find out what other acts impact your stratas, but this is a big reason why it's important to hire a lawyer, and why often when we see stratas writing new bylaws, we say that it is very important to hire a lawyer to help you write that new bylaw, because there can be legislation that you've never even heard of that impacts the bylaw that you're about to pass. Now we can go to the next slide. So first, the very basics, though, to go all the way back to the basics, bylaws and rules. The bylaws were put in place by the developer who built your strata, or they were approved by owners at general meetings. Council decides what motions are put forward at general meetings. Owners, if you as an owner wanted bylaw change, you can request council to do it. And then it's up to them whether to put it forward. Or failing that, you can circulate a petition amongst your fellow owners, get a bunch of signatures, and if you get enough signatures, you will force the council to put that motion on the agenda. And it is at least 20% of your votes. So usually that means 20% of your units. But commercial units can be worth different amounts of votes, which is a whole other topic. Rules, on the other hand, were put in place by councils at a council meeting. It's just the case that owners have one opportunity to vote that rule down at the next AGM, but that is, most rules come into effect as soon as council votes on them. Now, how to enforce these bylaws is one of the chief things that council members do. And usually this is framed in the sense of responding to complaints that some owners are breaking your bylaws. One owner complains about another. But it's important to remember that that's only one section of what bylaws do. Bylaws also set out how your council should run, how your annual general meeting should run, how your budget works. There's all sorts of things in your bylaw about how the day-to-day operations of your strata should go. And it's really important that you're familiar with those when you're making decisions about how you're operating as a council. And as noted, there are 1,001 limitations on what bylaws or rules can or can't do. We'll get into that. But now I'm going to turn it back over to Christy to go a little bit more in depth on bylaws and rules.
Fantastic. Thank you. So Dario has set us up nicely. We have bylaws and we have rules, but what's the difference? So there's some very key differences in terms of these two sets of guidelines, really. The difference comes down to how they're adopted and what they can address, and then what the potential consequences are. So as Dario had said, and we'll get into a little bit deeper here in the bylaws really are designed to govern the strata corporation. And as Dario mentioned, they touch on a variety of topics, including how your AGM runs, but ultimately they form your community's guidelines for living there. They are initially set by the developer of the strata corporation, and they may be tailored specifically to the community, or they may be what is referred to as the standard bylaws contained within the Strata Property Act. And ultimately, and most likely, the bylaws are the standard bylaws with some additions depending on what your community looks like. And then as your community grows and ages, your owners will provide amendments to the bylaws that are approved at general meetings to kind of, once you get a sense of what that community needs and what those bylaws should look like. Amendments, again, are to be made to the bylaws after that first annual general meeting once a strata corporation is formed. If you have professional management, your professional management does not make or approve bylaws. As a democratic community, you as owners have the say. So you will want to get recommendations from strata lawyers to ensure that you're drafting and reviewing bylaws that are enforceable, that accurate interpretation of other legislation is considered, and that you're putting forward something that ultimately can be useful in the future. Bylaws bylaw amendments cannot be significantly altered during a general meeting. So if your strata council is putting forward a bylaw amendment at your AGM or at a special general meeting, if there's a disagreement around the language of the bylaw, it might be most appropriate not to pass the bylaw amendment at that meeting so that a different version of that bylaw can be presented at a future time. You want to really make sure that the bylaw that you're adopting is something that ultimately fits with your community and is understood by the owners and residents that reside within. In terms of rules, rules govern common property. They cannot govern anything else. So if your community is attempting to put guidelines in place for behaviors within a strata lot, rules are not your avenue. Rules are created and amended by the strata council initially. They would move approval of a new bylaw, or sorry, a new rule at a duly convened strata council meeting. And then at the following annual general meeting, the owners would have a majority vote to ratify or essentially solidify that rule in place. Once the rule is adopted by the council at a council meeting, the strata council has a duty to inform owners and residents and prospective owners of that rule. And so generally what that looks like is obviously you're minuting the new rule. You may want to issue a notice to your Strata Press website to get that information out. And you may even want to post a notice in your building if you have kind of a community board that you can post to the new rule tool, just to make sure that everyone is aware the rule is in place and can start abiding by it. One note though, with regards to rules, if your strata council is adopting a user fee rule, so for example, if you want to charge a user fee for that parking stall that never really gets used and the strata wants to start generating a little bit of revenue, that user fee cannot be applied until the owners ratify approval of that rule at the general meeting. So it's great to have that on the radar in terms of adopting a new user fee. But again, you cannot actually apply the user fee until the owners essentially give their consent and approve that rule at that general meeting. Dario had alluded to the enforcement process, and he's going to take it a little bit deeper here.
Yeah, so when someone breaks a rule or bylaw, or you suspect them of having broken a rule or bylaw, what do you do? This can be one of the most stressful parts of strata living. It exacerbates the friction between residents if nobody's on the same page about how council should be responding to possible breaches of the bylaws. It's one of the most common things that stratas deal with, and yet it's, frequently one of the more complicated and stressful things. So we're going to quickly walk through the process, which is as detailed here: council receiving a complaint, investigating and considering how to respond, communicating back to the residents involved, and then how to proceed if the situation is not resolved by that. So on the next slide, first, council must receive a complaint. So this right off the bat is a source for some confusion and stress for people. Councils enforce bylaws on a complaint basis, and this is laid out in the Strata Property Act. So you can be sitting around as an owner wondering why council isn't doing anything about your neighbor who is causing all sorts of problems. But if council hasn't received any complaints in writing about the issue, there's not a lot they can do. And they might not even know that there is a problem happening. They're not omnipresent all over the strata. Something that's really bothering you, council who live in other places in the building might not know about it. Or you may have lodged one complaint and then the issue continues. Again, you wonder why council isn't taking any further action. Council might think that because the complaint stopped, that means that the issue stopped. It's important for you as an owner who has complaints, serious complaints, to file those complaints in writing with the council. If there are a lot of complaints to file, if it's going on and on, you might want to create a log of times, specific dates and times. Then you can send that to council on a regular basis instead of daily. But the more complaints you write in, the bigger a case that the strata can build against the person breaking the bylaws. And what you see here on the screen is if your strata has a strata press website, which most, if you are our client and you have a website, your website would be through strata press. You can find this on your strata's website. You can click this create a request button. A copy of this gets sent to all members of your council and your property manager as a way for you to email them your complaints and make them all aware of it. So be aware that that's there. Be aware as well that when you write these complaints, these emails become a official record of the strata corporation. As per the Strata Property Act, your strata has to keep your email on file, and you may even have to share your email to other owners, including the person you're complaining about. So if the issue escalates, for example, to the Civil Resolution Tribunal, the CRT will be reading copies of the complaint. The person you complained about has the right to review the complaint so they can prepare their defense against the complaint. And you should take that into consideration. Be mindful when you're writing complaints. Often we write complaints when we're the most upset. But sometimes it's worth that thing, write it out and then don't send it yet. Take another look tomorrow. Edit it again tomorrow before you send. The words you write are going to be a legal record of the Strata Corporation for years. And it's also important to understand that your Strata Council is not a police force. Their job is not to wander the halls looking for infractions. So again, it's important if you have concerns, write into council to make sure that you're aware, and also note that council is not responsible for responding immediately. If someone is smoking in a non-smoking building, council doesn't need to go break down the door and stomp out the cigarette. Nor is council responsible for staking out a unit for hours a day to monitor the smoking. This is beyond council's scope as volunteers, and the actual power of the Strata Property Act lays out a complaint process that involves, again, letters and writing back and forth, not council volunteers banging down doors. But on the next slide, council is responsible for investigating complaints to an extent. So what does council investigating complaint actually mean? Often it's as simple as writing to the person who the complaint was about, letting them know about the complaint, and inviting them to tell their side of the story. Sometimes it involves council coming over to hear something for themselves. For example, I sometimes hear a noise is pretty difficult for council to investigate. But if, my neighbor's TV keeps me up at night, members of council could arrange, for example, to come over. One of them stands in one unit, one of them turns on the TV in the other. They see for themselves how loud the noise is. It's important that council doesn't dismiss complaints out of hand, but also understanding that council, again, as volunteers, they're not meant to be detectives. Often the first step is to just communicate to the person who we believe is breaking the bylaws. So your neighbor is causing a lot of noise. The first step is often to just reach out to that neighbor and ask them, do you realize you're making this much noise? This communication is also an official record of the strata. So it should be specific and it should detail the bylaws people have broken. So generally at Proline, we consider two types of communication. Both of them give a quote of what the complaint says. Both of them lay out exactly what bylaws you're being accused of having broken. The reminder letter lets the resident know that a complaint about them has been received and fines may be considered for future infractions. An enforcement letter lets the resident know that a complaint has been received and fines are being considered for this infraction. And if you're on the opposite side of this, if you receive a letter from your council that a complaint has been made against you and you think the complaint is an error, I urge you to take that as an opportunity to give your side of the story. Council's received a complaint, they're reaching out to let you know about it. People often understandably get upset when complaints are made against them. It's never fun to get a letter that says your neighbors are complaining about you. But sometimes what I hear a lot is people asking, well, why didn't council look into whether the complaint was valid before sending me this letter? And I understand that reaction, but again, sending that letter is exactly how council investigates the legitimacy of the complaint. The strata has a duty to investigate, but they're not usually going to investigate you in secret by spying on you. They're letting you know about the complaint, putting the complaint back in the open, giving you a chance to respond. I think if we all thought about it, we'd rather be asked, hey, do you know that your smoking is bothering people? Do you know that you're making a lot of noise? with the alternative being that the council treasurer is sneaking through your rose bushes with a pair of binoculars and a notepad spying on you. That is not how councils are supposed to operate. Often having each side submit their story in writing, then having council make a decision about what needs to happen. Often that is enough to resolve a situation. But if it's not, the residents involved may request to attend a council meeting to speak out their side of the story in person. That's a hearing. The strata may have to issue fines as a deterrent against future violations or as an incentive for the resident to do something. And if that doesn't work, either the strata or the resident may refer the matter to the Civil Resolutions Tribunal.
Awesome. So what is an unenforceable bylaw? As legislation changes, some bylaws become unenforceable that may have previously been enforceable. So we've had quite a few significant legislative changes over the course of the last several years. And they have had a big impact on a variety of bylaws, some very common within strata corporations that have done exactly that, have rendered those bylaws completely unenforceable and thus somewhat confusing for any residents or owners that are not up on the Strata Property Act's legislative updates, but also are invalid and the Strata Council cannot enforce them. So, for example, the two on the screen here that have changed within the last several years are rental restrictions. So strata corporations could previously pass bylaw amendments at their general meetings with a 3/4 vote of the owners present to restrict rentals. And so what that means is you could potentially prohibit rentals previously. You could restrict the number of rentals to a specific number. So for example, a strata corporation could previously have adopted a bylaw that stated we only want 4 rentals within our strata corporation at one time. The other example of a legislative change that has deemed some bylaws to be unenforceable are age restrictions. There was a recent legislative change, and while there are some parameters that you are permitted to have a 55 plus age restriction bylaw, the vast majority of previous age restriction bylaws are not enforceable. And if you do have an age restriction bylaw, you want to look at that with a strata lawyer to ensure that if you haven't changed it since those legislative changes, you're looking at it to see if it is in fact still enforceable. It may need some tweaking to be consistent with how the legislation fits now within the Strata Property Act. There's also an example of a requirement to have insurance. So many strata corporations have this bylaw. It's not necessarily enforceable. There's no requirement of an owner to have insurance, and there's no ability of a strata corporation to require it. However, having said that, while it's unenforceable, it's obviously in all residents, all owners, and the strata corporation's best interest to ensure that owners have insurance to address any potential claims. And so there are many strata corporations that do have a bylaw like that, that isn't enforceable, but remains within the package. And frankly, some strata corporations simply adopt unenforceable bylaws because they don't get adequate legal support in advance of seeking approval from their owners. So going back to what Dario had said previously, it is really critical that strata corporations are obtaining adequate, proper legal advice before putting forward bylaws to ensure that you're on the right side of all of the legislation out there. In terms of limitation of bylaws and rules, there are many, but specifically time. So the enforcement and the dealing with bylaws and rules takes time. Your strata corporation and your council are made up of volunteers, and they cannot simply respond immediately to a complaint. Council has to receive a complaint, they have to meet, they have to come to a consensus amongst themselves. They may have to investigate and take additional steps outside of that meeting to determine if, in fact, the complaint is valid before they take any action. And they may also reach out to the complainant to obtain additional information. They may wish to reach out to the alleged offender, we'll call them, to get information from them before taking actual action. So all to say that time is always a limitation in the strata world. Unfortunately, things do not happen necessarily at the quickest pace. And it's because there are many, many steps to governing a strata corporation. And in particular, bylaw and rule enforcement is very specific and very much outlined by the Strata Property Act. And it's really important for strata councils to understand the proper procedure for enforcement so that down the road, there aren't any issues if a dispute arises. Another important limitation of bylaws and rules is specifically scope. And so we'll talk about this a little bit more later in the presentation, but there are some circumstances that are outside of the scope of the bylaws and rules and outside of the scope of a strata council to handle and manage. And so we think about that around police-related matters. Violence, harassment, interpersonal issues may not be something that your strata council will get into. You may have a bullying and harassment bylaw, you may not. And so the scope of the complaint is also something that may be limited. Now, there are also other pieces of legislation besides the Strata Property Act that impact stratas. And so we're going to touch on two of those today. One is a human rights code and the other is PIPA. And so the BC Human Rights Tribunal is responsible for accepting, screening, mediating, and adjudicating human rights complaints. And strata corporations within the province are required to ensure that bylaws do not contravene the Human Rights Code, as those bylaws would be deemed to be unenforceable. The BC Human Rights Tribunal has found that strata corporations are subject to the Human Rights Code in their relationship with owners, occupants, tenants, and visitors. So basically everyone. This means that the strata corporation and the council have a duty not to discriminate, and they have a duty to accommodate. And so if a strata council is found in a position where they are being requested to accommodate an owner based on the Human Rights Code, the strata does have a duty to accommodate those residents. And generally, we talk typically around disabilities and the duty to accommodate based on disabilities. That duty is to the point of undue hardship, which may involve changes to a property's rules or services. And so there are limitations around what that accommodation looks like. It has to be reasonable, but ultimately, again, the strata has a duty to accommodate. And so there's a strata lawyer in Nanaimo, Cora Wilson, who you may know. She once said that a human rights related complaint or piece of correspondence is like red light, do not go. You should not be moving forward with a concern around the Human Rights Code or a potential threat of a human rights tribunal complaint without legal counsel. That's kind of your red light stop. If you're dealing with a human rights related issue, it's time to probably seek legal advice. Moving on to PIPA, otherwise known as the Personal Information Protection Act. This piece of legislation intersects the strata corporation in terms of how stratas regulate personal information held by the strata corporation. So PIPA generally requires consent for collecting, using, or disclosing personal information, but the Strata Property Act provides exceptions allowing certain information collection and use without consent. It is a little bit tricky. It is quite complicated. The Strata Property Act does require that every strata council elects a privacy officer. This is a kind of a neat role within a strata corporation because the privacy officer generally is more up on privacy legislation and how to potentially address privacy related concerns. We here at Proline have a wealth of information and literature around the topic of privacy as it intersects with the Strata Property Act. And so we're more than happy to assist any privacy officer when they take on that role in terms of kind of getting familiar with the legislation, how it might impact the Strata Council's decisions. But at the end of the day, your Strata Property Manager is always there in your back pocket to provide assistance and support if any kind of privacy issue crops up. One important example of how the Personal Information Protection Act, PIPA, intersects the Strata Corporation or the Strata Property Act relates to consent to receive general meeting documentation. So for any owners or Strata Council members present here, you may have a Strata Press website. You probably have a Strata Press website. You might have consented to receive your general meeting documentation electronically. That is a very specific indication that you have to indicate within your settings within StrataPress. If an owner does not consent to receiving those general meeting documents electronically, they have to be mailed. And it's just, it's an important piece of the overall Strata Corporation puzzle to understand as it relates to privacy and those consent items. I'm going to throw it back to Dario to talk a little bit more about other external bylaws.
Yeah. So, you know, I find as we go here, we get even a bit further out from what you might expect. The Strata Property Act is directly about stratas. PIPA is directly about corporations, and strata is a corporation. But what about just like regular municipal bylaws that impact everyone? One thing that I want to note here is your bylaws, like these things don't even have the word strata anywhere near them. So first of all, how are you aware of these and what do you do about them? One thing I want to note is that your bylaws don't have to map perfectly onto municipal bylaws. And that's for a few reasons we'll go over in a moment. But it's important to recognize that municipal bylaws can be a very useful tool for you, but at the same time, not restricting you as a strata. For example, noise bylaws. So one of the big things that councils often deal with is what constitutes unreasonable or reasonable noise. Sometimes you hit an impasse with one owner constantly complaining that their neighbors are too loud, while the neighbors feel that they're just, it's just normal living noises. We're not doing anything wrong. And so how does council determine what's reasonable or what's not? And often in these cases, we're looking for a reasonable accommodation between the two owners, right? We don't want to punish one owner or the other necessarily. We want to find a sweet spot in the middle where both can be happy, reasonably happy. So many municipalities will have public noise bylaws. And these bylaws often actually relate to what hours construction is allowed to happen or things like that. Quiet hours is usually a big guideline that we're looking at here. And so again, I want to be clear that if your municipality has a 10 p.m. quiet hour, it does not mean your strata needs to observe the same quiet hours as what's in the municipal bylaw. Your strata bylaws might have different quiet hours. It might not have any quiet hours at all. And that's not the same as contradicting the act. That is just having different quiet hours than the municipal regulations for public property. But that being said, if you don't have your own for example, quiet hours, and you want some guidance on what's reasonable or not, sometimes knowing that municipal quiet hours start at 10 p.m. can be a helpful guideline. The flip side of this is just because it isn't quiet hours yet, doesn't mean that all noise is permitted. Most strata bylaws prohibit a nuisance. They prohibit you from causing a nuisance to your neighbor at any time of day for any reason. Someone might work from home. They might work nights and sleep during the day. It's not fair to simply tell those residents that they have to put up with noise from their neighbor because it's not quiet time yet. But again, it can be helpful in helping you determine what's reasonable. Pet bylaws are similar. If someone moves into your strata with a pet, you don't need to know if that pet meets all municipal requirements. You don't need to know if the dog is registered or neutered. I've had people ask, is that pet even illegal to have in this country? You don't need to know if the pet is a rare Colombian reptile dog with poison teeth. I don't know. Well, you probably want to know if it has poison teeth. But the point is that you don't need to know if the pet is legal by any municipal or federal guidelines. You just need to know if the pet conforms to the strata bylaws. And any other concerns you have about that pet, other than if it conforms to the strata's bylaws, are not a concern for council. They're a concern for law enforcement. And that's something we're going to get to in a second. But next, smoking. Smoking is another big one. If you live in the CRD, we've got in the CRD the Clean Air Act that governs where you can or cannot smoke on public property, but it does not apply to most private properties, which your strata home is. Again, the thing that determines where you can smoke in your strata is your bylaws, not the Clean Air Act. I've had complaints before about smoke coming in a bedroom window from someone smoking on the sidewalk. The sidewalk in that case was not strata property, it was the city property. The people smoking were not even residents of the strata. Again, it's not that council doesn't want to be helpful in these cases, but council doesn't have any authority in this case. The Strata Property Act does not allow council to enforce its smoking bylaws or on people outside the strata, and it does not empower council to enforce the Clean Air Act. It's not the council's job to police the streets. On the flip side, though, I do like to point out that while some stratas have smoking bylaws, some don't. Once again, almost every strata has a nuisance bylaw, something that says, thou shalt not annoy thy neighbor. So just because your strata doesn't have a bylaw that says no smoking, it does not mean it's open season to smoke wherever you want. If your smoking causes a nuisance to your neighbor, that's breaking the nuisance bylaw. And even if residents are allowed to smoke in their units, they can be asked to do so in a way that minimizes the impact on your neighbors. So I had a building once where someone was smoking on their balcony and the smoke was getting in the bedroom window of a neighbor. So we sent a bylaw letter that said, please smoke on the other side of your balcony. Again, we're trying to find a reasonable accommodation here. There have been other similar CRT cases where moving to the other side of the balcony didn't work. So the CRT ruled that the person actually had to go out of their unit and go onto the landscaping to smoke so that they weren't smoking next to their neighbor's unit. Again, reasonable accommodations. But in finding those reasonable accommodations, even though it's not the strata's job to enforce the Clean Air Act, you could look at the Clean Air Act, and the Clean Air Act says, for example, that you can't smoke within 7 meters of a doorway. Now, of course, your living room may be within 7 meters of your neighbor's doorway. You're allowed to smoke in your unit as long as you're not causing a nuisance. But that 7 meters guideline could be useful to council in helping to try that reasonable accommodation instead of just trying to arbitrarily pick, well, how far away should we ask them to stand? This can be a good starting guideline for you in determining what a reasonable accommodation might be. And the last one I'll talk about is the big one that we were all talking about last year, and that is the restrictions on short-term rentals. So as most know, it is now against provincial law for someone to own multiple properties and rent out those multiple different properties as Airbnbs. Your strata might also have bylaws restricting the rental of Airbnbs in your strata, but again, those are not the same thing. They don't necessarily have to be exactly the same thing. As with noise and pets and smoking, when you're writing your bylaws, you can use the provincial laws as a guideline for what your short-term rental bylaws should be. But when it comes to, for example, suspecting that someone is running an illegal short-term rental in their unit, that's not up to council to enforce. It's council's job to ensure that everyone in the strata is following the bylaws, but it's not the strata's job to ensure that everyone in the strata is following the municipal or provincial laws. It's not council's job to ensure that everyone who lives in the strata is paying their taxes on time. Those concerns should be referred to the appropriate law enforcement agency. And Christy can tell you more about that.
Excellent. So we alluded to it earlier, but there may be an appropriate time for residents, owners, and even the strata council to make use of the local police department and or municipal bylaw enforcement. Generally speaking, if there is any kind of violence, acts of threat to anyone's safety, etc., anything that falls into the criminal world, really that should be reported to the local police. In the event of violence, obviously 911 should be utilized, but for other criminal matters that are not urgent, residents may wish to seek advice from their local police department by contacting their non-emergency line. And obviously deciding what telephone line to call is up to that person. But again, if there's personal safety involved, 911 is the correct and should be used in that case. It's really important to understand that Strata Council members are volunteers, and they should never be expected to be put in dangerous situations to even address relevant bylaw enforcement issues within the strata corporation. Strata corporations typically have a bylaw that states that individuals cannot perform illegal activity within a strata lot or on common property. That doesn't mean that the strata council, again, should be putting themselves in a dangerous situation to investigate that. At that point, that really is an appropriate avenue to involve the local police. This is also extended to strata employees. So if your strata corporation has an employee, a caretaker, building manager, it's the strata corporation's responsibility and the council's responsibility to protect that employee. And so we really don't want to be putting those people in a dangerous position to investigate a potential bylaw issue or an issue that really isn't even the responsibility of the strata council. So for example, if you have a building with some transient homeless population outside sleeping on, a common property bench, it really isn't appropriate for residents to be asking strata council members to move those people along. That really should be a call to your local police department. And as Dario kind of touched on, short-term accommodation, municipal bylaws. Again, there are a variety of different municipal bylaws that do play a role in the strata world, but that are not the responsibility of the strata council to enforce. And so understanding the role that your local municipality plays and what their bylaws and how those bylaws interact with the behaviors within your community is important. There are times when you may want to reach out to municipal bylaw enforcement to address maybe a dog concern or a noise concern. Again, you can also contact the police if you've got, a 2 a.m. Sunday night party that's raging and, you've got a bunch of units that are disturbed and cannot sleep. It's not going to be the strata council running in to save the day at 2 a.m. That is definitely a police call to ask for help and intervention. So sometimes it comes down to common sense. If it's urgent, the police. Otherwise, you can put a complaint in writing to your strata council. But again, as we talked about, one of the limitations of bylaw enforcement is time. So having said all of that, a very quick overview of bylaws and beyond, we do have 10 minutes for questions. So we'll see. We have a number of questions in the Q&A feature at the bottom of Zoom. If you've popped any questions into the chat, we will prioritize the Q&A. And if we have time, we'll go to the chat. So if you've put a question in the chat, please move it over to the Q&A so that everyone can see it. The first question is, have we started? We definitely have. I think we're good there.
Yeah, are apartments with rental units supposed to have a strata council? Not necessarily. A strata is a very specific thing. It has to be filed with the government as a strata. Not all multi-residential buildings are stratas. If it's a rental building, that's something completely different.
Excellent. Next question is, what if council is aware of an infraction but does nothing because there's no formal complaint? What if council is aware of an infraction but does nothing because there's no formal complaint from a resident? That's kind of tricky. It's hard to know from the outside what council is and isn't aware of. I think when we live in strata communities, I think it's important for each member of that community to understand that we all play a role. And so as a resident, not necessarily on council, if you're aware of a bylaw infraction or contravention, and you would like it addressed, then it's your responsibility as the resident and a part of that community to communicate that to the Strata Council. You may think that they're aware, they may not be. And so putting that in writing and putting it out there really is the best step to ensure that it's addressed.
Proxy votes, how are they used, and how do I know if there's a record as to how my vote was used when I wasn't at the meeting? So at its core, a proxy is giving someone else your vote, the power to use your vote for you. There is no records kept of AGMs of how proxies are used. I mean, we don't even record for the people who are present who voted which way. We just record how many votes are one way, how many votes are another. In the proxies that we Proline do, we will give a list of the special resolutions that allow you to kind of mark down how you want the person with your proxy to vote. We do that for convenience. As far as the Strata Property Act is concerned, that kind of doesn't exist. When you give your proxy to someone, you are trusting them to vote in your best interest. You're trusting them if they maybe vote in a different way than you intended. It's because someone made a good point at the meeting and they felt that you would want to vote a different way. It's important that you trust the person that you're giving your proxy vote to, because there is really no way later to find out how they voted or if they voted the way you wanted them to.
Awesome. The next question is related to costs and carbon taxes, not really related to bylaws. So we're gonna skip over that for now. If we have time to get back to that, we can try to delve into it, but I'm not sure that even it is a scope that Dario and I can address right now.
Indeed. Same with the question, how does Proline operate? That is a very that could be a very big question. I would say go on our website, check the About Us section. If you have questions, reach out to us later. For now, I think we'll keep going with questions related to bylaws.
Okay, so next question. If a strata is situated as part of a larger development and security camera recording and security cameras record comings and goings into and out of strata buildings and shared parking, but the information is not held, managed by the strata, but by the developer or an external body related to the developer, how does PIPA apply to the strata in this circumstance? Frankly, Donna, I would love to answer that, but that I think is beyond the scope of today's presentation. Definitely worth having a conversation with your council and or your strata property manager to get into the more specifics around that. But there's likely a lot of background detail and documentation that Dario and I are not aware of in this setting. And so I'm afraid we won't be able to answer that one.
What rules, regulations, or guidelines guide the work of Proline staff? Again, not really bylaw related. So I'll just really quickly say that everyone who's licensed as a strata or rental manager is governed by the BC Financial Services Authority. So we're all government regulated.
Great. Next question is, does Proline provide any guidance for newcomers to Canada and condo ownership for issues related to ownership, such as speculation and vacancy tax, local recommendation for services, for example, installing tankless water heaters or getting assistance for upgrading services that are included as part of the strata, i.e. internet cable services? For the latter, I've had TELUS tell me to ask the strata and strata telling me to ask TELUS. We can in some circumstances, and we always, when asked, are as helpful as we possibly can to all new residents and owners to the strata corporations that we provide management services to. Some areas like speculation and vacancy tax are just not within our area of expertise. And so we would really recommend that in those circumstances, that residents and owners speak with a tax accountant or someone that specializes with that. We can try to delve into recommendations for service providers, given that we do have great relationships with lots of contractors from all the way from Sydney at the southern tip of the island to Campbell River. And so if you have specific questions, please feel free to reach out to your strata property manager. Where we can help, we absolutely will try to.
This is a pretty good question. We have an upper patio that the developer advertises being able to support the weight of a hot tub. We want to make a bylaw around this. but we don't have an official engineering report from the developer about the weight limits. Do we need to get an engineering report, or can we make any damage the responsibility of the owner? This is a complicated question, and it's one of those where the simple answer really is the best, which is whenever you're writing a bylaw, you should be involving a lawyer, because again, there's a lot of factors that the lawyer is going to be aware of. I think the short of it is you can request, the strata could get an engineering report if owners are installing their own hot tubs and it's going to be like an alteration request. The strata could request that the owner get an engineering report before council will give them permission. But it is certainly it's certainly a good idea to get an engineering report in these kinds of cases. Getting additional professional advice is always a good idea, I guess is what I would say.
Great. Albert asks, why can't you amend a motion at a meeting? So the Strata Property Act states that you cannot significantly amend resolutions at general meetings, and it's to respect those that are not present at the meeting. So for example, if Dario's strata was presenting a 3/4 vote resolution to approve a new hot tub, and the cost of the hot tub and the cost of the resolution was $20,000, but it was suggested and a motion was made to amend the resolution to cut the budget in half to $10,000 and go with a completely different hot tub because it's more cost effective, and that's a suggestion that sounds really great. We can't actually make that resolution or that amendment because there are likely many owners not present who will not be privy to the details of the discussion and may not necessarily vote in the same way that they indicated on a proxy had they been present at the meeting. So it's a matter of ensuring that all owners have the same information in order to appropriately decide on how they're going to vote for each resolution.
What should be done if your complaint is against a member of council? Conflict of interest policies, and what if council is not acting on the complaint? So firstly, if there's a complaint against a council member, I would definitely urge council to, when you get to that part of the council meeting that you're going to discuss that complaint, have that council member recuse themselves. Maybe you save it to the end of the meeting so that they can leave the meeting. I would even say oftentimes I've circulated complaints to every member of council except the one being complained about. This gives the rest of council the opportunity to discuss how they want to approach the complaint. The same way that any other owner, council is going to have the chance to review the complaint before you find out a complaint has been made against you. If council is not acting on the complaint, that's going to be a pretty serious conflict of interest. Couple things going on there, there's lots of things like, definitely make more complaints to council, speak up about it, talk about it at AGMs. Sometimes we tend to think that anyone who runs for council, we have to vote in favor of them. At the council election, it's up to you if you want to speak out against a council that's not acting properly. And in another sense too, filing with the CRT to say, here's a record of my complaints and council not addressing them. And this is another case where having a written record of all the complaints and all the instances going back however long can be really helpful when you file that with the CRT.
Excellent. So we do still have a number of questions left, but it is 3 o'clock and we do want to be respectful of everyone's time. So we won't be able to get to all of the questions. I do encourage everyone whose questions were not answered to reach out to your strata property manager, or you can reach out to Dario, myself, or Catherine as well, and we can put you in touch with them to make sure that your questions are addressed. Otherwise, we really thank everyone for attending. I think Catherine has some a little bit of wrap up dialogue, but again, thank you.
Thanks, Christy. It's more of what we were just saying. We did have a couple questions about, will the recording be shared? Yes and yes. We did record the session. It will be sending out a link. So if you're here, you will get an email with a link to the recording that you can watch yourself, rewatch, share with whoever you think it might be pertinent for. It will also be posted to our YouTube channel. Like I said at the beginning, we do have a YouTube channel. There's lots of information on that. And so every time we do one of these sessions, we post the recording there. So you can find out about Strata Corporation just in general. You can find out about plumbing. There was a really interesting lunch and learn done earlier this year. I learned a lot from. So please look into that. And as mentioned at the beginning, if you have any questions or comments, please complete the survey at the end of the session. It'll pop up automatically, or feel free to reach out to me directly. And I'm just going to forward your questions along to your property manager if you send them in that way. So that they can help you with those things. And we're also always working on new sessions. And so we do have the year kind of planned out, but we're happy to get feedback and ideas about what people would find really valuable to learn about. We're embedded in this world, and so it's really second nature. And so it's wonderful to get fresh eyes on it and to know what you who are living and being part of your communities would really find valuable in learning about. So feel free to send that information. And that's all for us for today. Thank you for joining us. Have a wonderful rest of your day. Enjoy that fantastic summer feeling sunshine.